A, a real problem and sometimes very complicated issue arises in corporate restructuring and merger and acquisition cases where a successor corporation is saddled up with liability from an old corporation. I have seen two instances of this in the recent past. One instance when Corporation X wanted to buy Corporation Y's assets as well as actually liabilities. Basically, they were stepping in. Uh, I was consulted on the merger and acquisition transaction, and I noticed that there was a substantial number of H1B holders in the corporation being bought. So my suggestion was that we should have a certain amount of money in escrow so that if tomorrow there is a problem with the government, we can have a fund for fighting as well as reimbursing the government. And we kept that money for a certain number of years. Sure enough, within 7 or 8 months, very ugly issues surfaced, including some criminality being attributed to the seller of the old corporation. And all I can say is that we were very fortunate we had that fund so that we could deal with the issues raised by the government. Another time, we had a Department of Justice investigation in which DOJ wanted to know if the sellout by the corporation which they were holding liable for certain violations was merely pretextual. They wanted to know if our client had basically been a party to a sham transaction to avoid liability from DOJ. So when you have corporate restructuring and merger and acquisition, there is a certain amount of care that has to be taken. You don't want to take on old liabilities and you don't want to unintentionally assume liability. I think certain amount of contract drafting, some right sorts of clauses might help there as well. But this is also an area of the law which is largely untested. And a lot of what we know about this area of the law comes from civil rights laws. DOJ looks to civil rights laws to see how to assign liability in certain circumstances. Bear in mind, your responsibility may extend to independent contractors and what they do, especially if you know what they're doing. Um, Normally, an employer is responsible for their own workforce. You don't have to go looking at independent contractors' workforces. But the Walmart investigation um, ended up in an $11 million settlement and just egg on the face of an employer whose key workers, key officers knew that the cleaning crew that was being used by the independent contractors was, in fact, illegal workers who did not have proper work authorization. So $11 million again is a healthy chunk of change. It's not, I mean, it can be a lot bigger than that. The government has been getting more and more aggressive. And we are seeing definitely criminalization of conduct that was earlier considered to be merely an administrative violation or a civil violation. For government contractors, you have to be ultra careful because now, under the acquisition regulations, you can be barred, your client can be barred from federal contracting if they have found to if they are found to have violated immigration laws. In the handout, I have attached the executive order from President Clinton, which started this trend, this debarment for immigration violations, which was kept alive by President Bush and finally incorporated into federal acquisition regulations. Also, I have attached, I think it's a 2008 press release where Department of Homeland Security immediately cracked down on 7 so-called violators. We don't know what happened with those cases eventually, that were being placed on the no contract or the contract debarred list for having violated immigration laws. So it's a real danger. It's not something that's imagined or remote.